Okay. On the record, in the matter of the people of the state of Michigan versus Duaname, file number 23-02204 SM, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Thank you, Honor. Tiffany DeBruin on behalf of Duaname, who is currently seated at council table 208.
Okay, how are you, Miss May? I'm well, thank you. Okay, today was the date and time set for jury trial. Let me get some jury members into the jury box. Seat number 1 is going to be Tammy Baker. Come around this way. You gotta come this way. And then you'll walk in and go all the way in to juror seat number 1. Juror number 2, Amanda Schopp. Pepe, okay, thank you. Juror number 3, Greg Boldman. Juror number 4, Christina Ward. Juror number 5, Scott Norris. Juror number 6, Molly Corpening. And juror number 7 is going to be Patrick Forstead. Okay, you're gonna come take a seat here. Zoom in for this experience, because we already know what's gonna happen. Okay. Okay, if you want to turn your attention to the screen here, I do have some preliminary instructions. Okay, ladies and gentlemen, I am Judge Kristen Simmons, and it is my privilege and pleasure to welcome you to the 54A District Court of Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for one side or the other. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A jury trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called the Voir. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that may influence you for or against the prosecution, defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. All right. Leave those back there. Thank you. Great. Well, of course not you, because you're not a juror. Raise your right hand. Okay. Everyone has their right hand raised? Very good. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, signify by saying, I do.
I do.
Thank you. You can be seated. Let me introduce members of the court staff. To my right is my judicial assistant and court recorder. That's Miss Addie Nash. Over here with the sweater with the red polo man is my court officer. His name is Remington Whitman. I have borrowed Judge Buchanan's court officer, David Wormsley. He's here to train Mr. Whitman. This is a criminal case involving the charge of domestic violence, which I will explain more fully later. This charge has been made against the defendant, who is Duana May. The defendant's attorney is Tiffany DeBruin. Mrs. DeBruin, please list any witnesses you anticipate calling today or later in this trial.
Thank you, Judge. We will call, anticipate calling. Give me 1 second, Judge.
Take your time.
Michael James Delamurder, Zachary Thornburg, Katrina Greskell, Irene Furman, and any other necessary witnesses, Judge.
The assistant prosecuting attorney is Ms. Paige Petrosky. Ms. Petrosky, please list any witnesses you anticipate calling in this trial.
I anticipate that we'll be calling the victim in this case, Mr. Stephen Rutherford and Officer Hannah Robeson.
Does anyone in the jury box or anyone waiting for their chance to be in the jury box know the defendant or any of the lawyers or the witnesses that were named? If you know them, raise your hand. Very good. We believe this trial will last 1 day. If you believe the length of trial will be a real hardship for you, please let me know now by raising your right hand. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? That one always cracks me up, because who can sit for 2 or 3? You don't have a medical problem to not be able to sit for 2 or 3 hours at a time. We won't do that. But if you have a problem that makes you unable to sit for an hour at a time, please raise your hand. Okay. Does anyone have a sight or hearing problem? Everybody can hear me? Very good. Everybody can see us? Very good. This is a criminal case. The paper used to charge the defendant with the crime is called a complaint. The complaint, oh, that should have been edited, charges the defendant, in this case, Dewana May, with domestic violence, and it reads as follows. On or about June 22nd, 2023 at 1119 North Walnut Street, City of Lansing, Ingham County, State of Michigan, that the defendant did allegedly in count one commit the act of domestic violence, and that the defendant did make an assault or assault and battery upon a Stephen Rutherford, a resident or former resident of her household, and or an individual with whom she had a dating relationship, contrary to Michigan compiled law 750.812. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal case so that the defendant and jury can hear the charges. You must not think that the evidence, or this is evidence that of her guilt, or that she must be guilty because she has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. We will begin with voir dire. Ms. Petrowski, you may proceed.
Thank you, Your Honor.
You're welcome.
Good. Well, I believe it's still morning. Good morning, everybody. And good morning to all of you. Voir dire is to give both parties the opportunity to get to know prospective jurors and ask a bunch of questions. They might seem like kind of nosy questions, but I'm not intending to embarrass anybody. I just need to get some information and just know there are no right or wrong. I want to hear your honest opinions. Our goal is to find people with open minds and select a fair and impartial jury for both the people of the state of Michigan and for the defendant. So I kind of like to start with some easy questions. Ms. Baker, what do you do for a living?
I'm a certified nursing assistant.
Okay, and how long have you been one?
35 years.
Put your hours in. Do you work with a team in that role? Yes. And you, how does like attention to detail? Like, do you have to focus on a lot of things at once?
Sometimes, yeah.
And then I apologize, I didn't hear your name.
Amanda Sheppy.
You're Sheppy. Okay, I thought I had Schultz. Okay. So, what do you do for a living, Ms. Sheppy?
Social worker.
You're a social worker. And how long have you been a social worker?
4 years.
Okay. You work with a team? Okay. And is attention to detail something that is important for your job? And Mr. Boltman, are you a teacher? All right. What's your occupation?
I'm a teacher.
How long have you been a teacher? What grade do you teach? You see middle school, I mean?
I currently K through. I've taught everything from preschool to high school.
All right. I'm guessing in that role you've worked as a team quite a bit. And then Ms. Wood, what's your occupation?
I'm a financial contract.
How long have you been in that role?
About 5 years.
5 years. Do you work as a team in that role?
And yes, I just sit more than 2 or 3 hours.
Okay, good to know. And then Mr. Norris.
Yes.
Good to meet you. What is your occupation?
I'm an attorney.
So you're an attorney. Okay, what kind of law do you practice?
I'm retired now, but I spend a great deal of time as in-house counsel for insurance company, monitoring litigation.
Okay, cool. Interesting. When you were in that role, did you work as a team?
Yes.
And as attorney, no intention to do that.
Yes.
Yes. All right, so we've got Miss Corpenny.
Yeah.
What do you do for a living?
I do resident assistant work and then care.
Okay. Do you work as a team in that role?
Resident assistant, yeah.
Okay. Oh, resident, are you at MSU?
No,
Right.
I just work as assistant.
Oh, my. All right, and then Mr. Forstick, what do you do?
I'm the director for the Student Veterans Resource Center and faculty.
Okay. And then do you work as a team in that role?
So myself,
Are you capable?
sure.
Okay. All right, so. I want to talk a little bit about you, your prior history with kids. So has anyone here previously served on a jury? All right, was it a civil or criminal case? And do you remember what the charges were? Is there anything that you particularly liked or disliked about that experience?
I found it was just with putting all the information together. Following the process, so everything.
And was that jury able to reach a verdict? Was there anything that you found difficult in trying to come to that verdict?
Some people had difficulty following instructions. So bringing a lot of imaginary, bringing what if scenarios and things like that.
And was there anyone else who had been on the jury?
Only to the extent of Roger.
Picking one, yeah. And so for the rest of you who haven't, do you think you would be able to, if you felt that I had proven my case beyond a reasonable doubt, would you be able to return a guilty verdict against the defendant?
Yes.
Got a yes from the speaker, yes.
Can you use their juror numbers for the
Oh.
record?
My apologies. The report doesn't hold up. So I got a yes from the speaker.
Juror number one.
Juror number one. And it was a yes from juror number two. And question applied to you. So a yes from juror number four. Juror number five.
Yes.
Six.
Yes.
Okay. And some people have personal religious beliefs that they can't judge another person. Would that affect anybody's ability here today?
No.
Notes with all the jurors. And if you were absolutely convinced by the evidence that the defendant was guilty beyond a reasonable doubt, everyone else in the jury thought that that person was innocent, would you be able to stand by your convictions?
Yes.
And let's say juror number two, even if you had been there all day, it's already been a long day, but you've been there all day and everyone just wants to go home, you still be able to stand by your conviction? Juror number one?
Yes.
Yes.
All right. So we're going to talk about some other interactions you might have had with the justice system. So has anyone had any interactions with police officers?
I was a police officer.
Well, you were, okay. So given your experience there, would that affect your ability to listen to an officer's testimony?
I have the department.
Okay.
Yes, it would.
Would you be able to listen and weigh their testimony just like you would anyone else?
Yes.
And you would evaluate them for their credibility just like you would a non-law enforcement individual?
Yes.
And then you were law enforcement. Who else saw? Okay. Jury number two.
As a social worker, I have to like file CPS and work with that manner.
Okay.
Can you speak up, please?
Oh yeah, I'm so sorry. As a social worker, I've had to file CPS and work with police officers in that aspect.
Generally speaking, have those been good or bad experiences for you?
I would say neutral.
It's okay, that's fair. Would you be able to listen and weigh an officer's testimony just like you would anyone else's?
Yes.
And you'd be able to determine them credible or not credible, just like anyone else?
Yes.
Thank you. Jury number five.
Yes, I've taken their depositions and cases before, pieces of trial and things of that nature, and monitored and involved in reviewing their testimony in the cases that I oversaw for the company.
And would that affect your ability to weigh an officer's testimony? Either good or,
By the extent of my having experience, I think it's helpful.
okay, that's fair. would you be able to evaluate and make a determination of credibility for them, just like you would any other witness?
Yes.
And then jury number 5, the last one with officer interaction. Have you been convicted of a crime?
I was on probation once.
Okay, so, and what was that for?
Simple assault,
Okay. How long ago was that?
about 30 years ago.
Okay, and where did that, where were you convicted? What county?
Ingham.
It was Ingham? Okay. Do you think that your experience with the justice system as a defendant, would that have an effect on your ability to find for or against the defendant in this case? And has anyone had to deal with the prosecutor's office, either as a victim or a witness? Unanimous.
You mean this prosecutor's office? not
Penny.
the prose- Yeah, well,
Penny.
yeah, obviously.
Oh, yeah, as an officer, right, of course. And then would that impact your ability to sit here on the trial today? Now I'm gonna get into,
And I
yes,
guess, you know,
Oh,
the
yes.
same responses as a witness in the case, I might have been involved in as an attorney.
understand. Would that affect your ability to be on this, sit fairly on this trial today?
No.
Now, we're gonna kind of move into some legal concepts. There's a couple of things that I'm gonna kind of go through. We're gonna make sure that everybody kind of understands the way this works, because it's complicated and so. And what you're gives me a chance to make sure that everybody kind of on the same page about what the law is. So first I'm going to talk about direct and circumstantial evidence. So the judge is going to read you an instruction. It's going to define both types of evidence. And in a court case, facts can be proven by direct evidence from a witness or an exhibit. So direct evidence is what you can actually see or what you can actually hear. For example, if you look outside and see that rain is falling down, that's direct evidence that it is rain. But facts can also be proven by indirect evidence or circumstantial evidence. And so that's evidence that normally or reasonably leads to other facts. So if you were to see a person come inside from outdoors wearing a rain jacket and the jacket's covered in water, that would be circumstantial evidence of the fact that it was rain. So juror number 4. Do you have any opinion or prior knowledge about whether direct or circumstantial evidence is stronger?
Direct.
Okay, so that's a pretty common assumption, but judge is also going to give you an instruction that states that circumstantial evidence by itself or as a combination of other circumstantial evidence and direct evidence can be used to prove the elements of the crime. So in other words, you should consider all of the evidence. That something that we can all agree to do?
Yes.
Okay. I know it's different than how you think about it in like kind of pop culture, but so you should consider all evidence. Does that make sense?
Yeah.
Jury number 1, jury number 2,
Yes.
Yes.
3, 4, 5, 6.
Yes.
Thank you. All right. So we're going to talk a little bit more about kind of how these two types of evidences work. I'm going to use an example, excuse me. Juror number 2, do you have any children or siblings? Sibling? Are they older or younger?
Younger.
Younger, okay. So did they ever play any sports?
Yes.
So let's just say you're at your sibling's baseball game, growing up, I should ask, brother and sister, brother, all right, yeah, we'll go baseball. So lay the scene, you're at the baseball game, the score is 0-0, no one on the bases, and it's the bottom of the last inning. Your brother steps at the plate, you see the pitcher start to throw the ball, but then right as they let go of the ball, you drop your popcorn and you pop all over the bleachers, you're straight. Can't see, you're looking down. When you are looking at the ground, you hear the crack of the bat, and you hear all the parents around you cheering. When you look up, you see your brother hopping around looking happy on top of the baseball, on top of the home plate. So what just happened? Did you actually see that happen? But what clues or evidence did you use to determine that he had hit a home run?
We heard it and cheering.
Yeah. And would that be direct or circumstantial?
Circumstantial.
Technically hearing the crack of the bat yourself, that would be direct because that's something you yourself heard. But all the rest of it, circumstantial, so good job. So as jurors, you're allowed to weigh direct and circumstantial evidence. We're gonna move on to the next of my legal topics here, presumption of innocence and reasonable doubt. So, juror number 7. Well, actually, no, you're an officer, you know. Okay, we'll go juror number 6. Have you heard the phrase beyond a reasonable doubt used before?
Yeah.
And what does that mean to you?
Um. Have I doubt that you have in your mind about what was said or what was done?
So you believe that it means something happened with 100% certainty?
Right.
Okay. So what's something that you know has happened with 100% certainty?
That I was born.
All right, that's a fair one.
Right.
Okay, I'll give you that. I'll give you that one.
Right?
I'll give you that one. Okay. Generally speaking, except for circumstances where the only possible answer is a human was born.
Okay.
It's really, really difficult, borderline impossible to, without being present for the crime, watching it happen yourself, watching it from multiple angles, multiple perspectives, and being able to, read the minds of everyone present, to know with 100% certainty what happened. Instead, the law doesn't hold me to that standard. I don't have to prove all of those things because that would be impossible. As a prosecutor, the law holds me to the standard of proving a case beyond a reasonable doubt. We've heard a description, and it's difficult to explain, but reasonable doubt, it's not an imaginary or possible doubt. It's a doubt that comes out of care and considered examination of facts. Let's go back to the baseball thing. Juror number 3. Can you be 100% sure that, well, let's just say you were there, but that juror number 2's brother scored a home run?
No.
Is it technically possible that while you were cleaning up your popcorn, simultaneously the scoreboard had a glitch and everyone, your son hit up, or the brother hit a foul ball, everyone just started cheering for no reason? Is that possible?
Well, my sons all play travel baseball, so no, that's not possible. My kids
Fair.
don't play, but yes,
Yeah.
yes, it is possible. Highly unlikely. But possible.
Yeah, so is it a reasonable possibility
Yeah.
that the home run wasn't scored based off of all the evidence that you have?
All the evidence put together, it's, I would say it's highly likely that it wasn't.
Okay. So since it is highly likely, there's not a reasonable possibility. Would you be able to come to a conclusion that to the standard of beyond a reasonable doubt?
Yes.
Either you got me again. So would anyone here not feel comfortable saying that to the standard of beyond a reasonable doubt that the home run wasn't scored? Not getting any guesses, so. Okay. So then taking kind of this example into the courtroom here, if I were able to prove the elements of my case beyond a reasonable doubt, would you be able to return a guilty verdict, even if I didn't prove it with 100% certainty? Yeah. Yes, from number 1, for 2, 4, 5,
Yes.
6,
Yes.
and 7. And can you all agree that you're not going to hold me to a higher standard of 100% certainty or even a 99, because you can't, reasonable doubt is tricky, you can't use percent. So you can all agree that you hold me to just the reasonable doubt. Yeah, yes. Unanimous consensus. The next, we're going to look at witness credibility. So the judge is going to give you an instruction that it is your job to decide which witnesses you believe and how important you think that their testimony is. So it's besides for number 3 here. Does anyone else have any children or maybe younger siblings or? You do? Okay. So juror number 7. Oh, okay. So I don't have kids, but I'm the oldest of all the cousins and siblings. So I wrangle little ones and stuff. Have you ever had an incident where maybe you're in the other room, relaxing or cooking dinner or something, and you got the kids in the other room?
Oh, yeah, sure. Yes.
You're good. You're good.
I thought there was more.
No, there's
Yeah.
going to be, but and so have you ever had it where when you're not able to watch them, some sort of trouble starts happening and you have to determine who did what.
Yes.
So let's say you're in the other room, kids are in the living room. And you walk into the living room and you see crayons all over the walls or markers all over the walls. What kind of evidence or clues or what would you look for to determine what happened?
Paint, if it was paint instead of crayons, I would look for paint, but crayons are gonna be pretty hard to prove.
Okay, if the kids are still in the room.
Sure,
Does anyone else have any ideas of what they might
I mean,
look for?
my question is, you're probably the person holding the crayon, but I also don't know who was holding the crayon when it was drawn, so
Okay, yeah.
I know what you're about, yeah.
Yeah. So could you maybe look at where the kids are in the room?
If I was really, really fast to get in there before they could possibly move,
Fair point.
yes.
And maybe you could look at, I guess if it's marker, if one kid has marker all over his hands,
Sure.
would that be something?
It's
you
a
could-
paint example.
Yeah. Would you ask each of those kids what their story, what they were doing?
Possibly, I would assume they probably have, tell me what really happened.
Okay. And would you feel comfortable even if both kids told you that they didn't do it? If you felt that one of those kids maybe had marker all over his hand, or maybe that kid, I don't know, reason someone else was wrong. It basically, if the clues you had discovered made you think this child number one did it, child number two didn't, but they both said they didn't, would you feel comfortable as a parent saying child number one did it?
Sure, yes.
Does anyone here not feel comfortable deciding whether or not someone is credible? No, yes. And does everyone feel like they can look at the direct evidence and the circumstantial evidence and make a decision about who is telling the truth? Yes, from 1, 2,
Yes.
3, 5,
Yes.
Yes.
okay, thank you. All right, so we made it through the legal concepts, the boring stuff. So now I'm gonna talk a little bit about domestic violence. Have any of you or someone close to you been in a domestic violence situation, either as a victim, someone close to a victim, or even someone who was accused of it?
Yes,
Juror number 1, do you want to talk about your experience a little bit?
my sister, her boyfriend was always beating her up and she ended up in a domestic violence shelter
Oh, wow.
for a while.
Did she report it right away?
No, well, not right away because he beat her multiple times, but that one time, I think a couple of times she did.
And how did you find out about it?
She told me.
How did it affect her?
um, Well, she was pretty torn up about it, I guess. Because
And how did it affect you?
I was mad.
Yeah.
Like I wanted to kill her boyfriend, honestly, but of course I didn't do it, but
Thank you.
the thought was there, but
Why do you think your sister waited to report?
well, I think she was afraid of him more than anything.
Do you
And
think,
she kept saying she loved him, you know.
yeah. It's a complicated, yeah.
Yeah.
Do you think that was less likely that he beat her because she waited to report?
No, I think it's just how it is.
Was he ever prosecuted?
Yeah.
And what effect did that have on the family?
I was happy. I think she more made my brother was happy about him being prosecuted for it finally.
Yeah. And do you think your experience with your sister, do you think that affects your ability to sit here on the jury and reach a fair and just verdict?
That I can?
Do you think it affects it in any way?
No,
Affects your ability?
no.
Did anyone else have any other? Has,
Yeah, a lot, but
yeah.
it's, yeah.
as an officer, yeah.
But I assume you mean personally.
I meant in a personal capacity. Yeah. One,
Not personal capacity, again, it's a social worker. Had clients on that had committed domestic violence, had clients that had
seeing kind of both sides of it, from both perspectives. Do you think that that has any effect on your ability to sit here today? Audrey? Your number four?
I had a neighbor.
Okay. Okay. How did you find out about it?
I came home from work and she and her son.
Yeah. Did you, excuse me, did you know if she reported it right away?
I don't believe she reported it right away. She just waited.
Why do you think she waited?
I think she was back.
Sometimes do you think that sometimes it takes a little bit for people to make the decision to go forward and seek law enforcement?
In that particular circumstance.
And do you think that experience, does that impact your ability to sit here on jury today?
No.
And 6 or 7, here you guys? Okay. So what does everyone, you can just raise your hand or let me know, what do you guys think constitutes a domestic assault? Like what types of acts are domestic assaults? Number one.
It's pretty much assault to me. Assault and or battery to somebody that lives in your household.
Well, that's pretty much spot on. So I'm gonna get into a little bit more detail, but thank you. So what types of like, would a hit, would that be considered an assault or battery?
Yeah.
Yes.
What other things kind of like that? Pushing, okay.
Putting somebody in fear of harm.
Okay, yep, so that's the definition for assault. Got me there, Mr. Ward. Number 6. So, yes, so the legal definition of domestic assault is somewhat more limited than what we think of technically as like domestic violence. I think domestic violence generally, we think of it as something a bit more broad, but domestic assault is pretty narrow. I have to prove 2 things, and those things are, well, those things are called elements. So first I have to prove that there is some sort of domestic relationship. So there's a couple different ways that someone can be in a domestic relationship. Juror number 3, what's one type of domestic relationship? Marriage, spouses. There we go. So current or former spouses. Number 6.
Children?
Yeah, children in common. That's one of them. We'll go. What's juror number 2?
household members.
Yep, current or former residents of the same household. Then there's one last one. We'll go jury number 7.
Domestic partner.
Yeah, so if you're in a current or former romantic partners, so
Okay.
you're in a romantic relationship. Does that make sense to everybody? Those different types?
Yes.
Okay. And then we've sort of gotten started on it, but I want to talk a little bit about the difference between assault and assault and battery. Okay. So the way that we learned it in law school is an assault is sort of like when you raise your fist in the air, you're about to punch someone. Okay. Whereas the battery is when you actually make contact. Now, both of those, either an assault or battery, either of those can constitute a charge of domestic violence. So that makes sense that either putting someone in the immediate fear or actually physically touching. Make sense to everybody?
Yeah.
Okay. So the definition typically is a forceful, violent, or offensive contact with a person, something closely attached to them, or putting them in fear that you're going to do that imminently. And I have to show that it was done intentionally, so that the defendant intended to make that assault or that battery, and that the victim was against their will. They didn't want it to happen. That makes sense? Yeah. What kind of clues or evidence could you use to tell if a battery was intentional or not? Number 5.
Whether there was some spoken words or comments made by the person that allegedly had committed the battery.
Okay, yeah. Anyone else?
The location of it, where if you have defensive wounds or like where the battery occurs on the person.
Okay, yeah. Anyone else?
How many times it happened, how many injuries they sustained.
Okay, yeah. Those are all great answers, and those are all things that you should be looking for as jurors. Does there need to be a serious or even any injury for a battery to have taken place?
No,
And why is that?
because some people don't bruise like. Yeah, I mean, you could hit somebody and they not have marks on them,
Yeah, that's a really good.
bruises
Yeah.
or.
That is a great example. So under Michigan law, judge is going to tell you this. There does not need to be an injury for someone to be found guilty of battery. However, if there is an injury, you as the jury, you're allowed to consider that injury along with all of the other evidence in the case in determining whether or not a battery took place. Does that make sense?
Yes.
So you, jury number 1, gave a good example of maybe someone doesn't bruise if they were hit. Can anyone think of any other examples of batteries that might not leave an injury?
The individual may not be strong enough to.
That's fair. Yeah. But would it still be a battery if they,
Yes.
what if, let's say, a woman runs up to jury number 6 in the parking lot and just grabs a handful of your hair and yanks? Would that be a battery?
Yeah.
Okay. Why is that?
Because she injured me personally.
But did she injure you? Okay.
If she yanks my hair, I'm gonna be hurting a little bit.
Yeah, so you'll be sore, but like,
Right.
I couldn't look at you and know that someone had done that to you, right?
No, if there's not chunks of my hair, then no.
Okay. Yeah. How would you be able to prove that that happened to you?
Security tape footage, if there's around, if I'm in a parking lot, dash cams, witnesses. There's another witness in the car with me, someone that is there, experiencing what I'm experiencing.
Yeah.
Evidence like that.
Those are all very good answers. That's we're gonna go to sort of a different scenario, but thank you for your answers. Those are perfect. We just kind of got through the holiday season, so I'm sure everyone is spending lots of family time together, probably close quarters. Let's say juror number 5. Are you married?
No.
So you're not? I'm gonna pick someone else, sorry. Juror number 7, are you married?
Yes,
And what's your spouse do?
she's a therapist.
So let's say you and your wife are over, you're in a heated argument about who's responsible for bringing the casserole to grandma's, okay? Both of you know you're right. Both of you are like, no, it was the other person. Things are heating up, maybe you guys are yelling. Is it an assault or a battery if the two of you are just yelling at each other?
No,
What if your spouse raises their hand up like they're about to?
that would be assault.
And what if they actually did hit you?
Then there's a battery.
Is it still battery even if you guys were arguing beforehand? Does the arguing negate the fact that a battery took place?
No, it has no effect.
Does it affect it at all if you're a man and your spouse is a
No.
woman? So. Do you feel like it would be inappropriate to report your spouse to the police?
No,
Why is that?
ending the cycle of violence.
Very good.
I've been trained.
Yeah, yeah. Does anyone here believe that the state and the courts shouldn't be involved in domestic violence cases because those are private matters? That should be like handled at home.
No.
No. And excuse me, if you, say, juror number 1, if you had heard testimony about juror number 7's wife hitting him during an argument, and the evidence taken all together proved that she did in fact hit him, proved it to you beyond a reasonable doubt, would you be able to render a guilty verdict?
Yeah.
Juror number 2?
Yes.
4? Yes. 5?
Yes.
6? Yes. And 7? And
Yes.
bias, but you know. Alright. And then are there any other reasons that you can think of that you feel you cannot be a fair and reasonable juror of this case?
Yes, but it more for training standards for Michigan law enforcement. Having worked in another state and come here and seen what their training is, I would very much question the officer testimony.
Okay, and question in what way?
Just I grew up in family law enforcement. I have law enforcement in the community right now. And I know how they act, what they, you know, what their training, again, their training standards are. I had more training on domestic violence police academy than most people get in their entire career. So
Understood.
I'm happy to do it, but I am gonna have a much higher standard.
Higher standard for
The law enforcement.
For law, okay. Do you still feel, when you say you have a higher standard, do you have a higher standard for the quality of their testimony?
Yeah, quality testimony, the elements of the crime, how they're reporting it, how they're describing how they reported, how they showed up, who they talked to, how they talked to them, what other agencies were there. I mean, that can go on, but I'm gonna really scrutinize that part because they're professionals.
Okay. No further questions?
I don't know if, I think my board here might take a little while. Just wanted to let the board know. Guys, I'm gonna post up over there, so give me a second to move. My name is Tiffany DeBruin. I represent Miss May. I've got an intern over there. His name is Matt Nickel. He's just kind of hanging out. He's observing and reporting today. So I had some follow-up questions for you after Miss Petrosky. So this is just a conversation. You're gonna hear us talk. I probably need to think of it. So this is really your opportunity. I want to hear what you guys have to say. Don't shy away from answering the question honestly. I had some follow-up based on what you guys have in your sheets. So juror number 7.
Yes.
It's gonna be hard for me not to call you right names, even though I might not be able to pronounce them, but I
The
am
Y
gonna.
is just there to make everything complicated.
Okay, fair enough. So I am just gonna refer to you by your numbers. It's not a disrespectful thing. It's just what we've been asked to do. So you talked a little bit about your training. Why do you feel like it's really important that officers are trained correctly on domestic violence?
I mean, it's the single most dangerous place you can enter as a police officer.
Okay.
You know, where I was a police officer, we worked at 2-man cars, so we always had a person with it, but every officer involved shooting almost always involved in domestic violence case. So
Sure.
a third, or no, I'd say probably about at least a month out of a 6-month academy is entirely devoted to that. It's an incredibly dangerous situation, and it's usually very little evidence. People don't have cameras out, you know, you're talking to people and you're relying on people's stories, injuries on people, their relationship. I mean, it's just very risky, and there's not a lot of, I don't know how to describe. It's been a while now. A lot of, you know, again, that hard evidence. You know, there's no one say, oh, here's a video of somebody hitting somebody else. It's easy. It's
Well,
much more complicated.
It is super interesting because you guys are going to see a 20-second clip that has part of the evidence on it. So you have that smoking gun in this case.
Potentially.
Interesting. Why do you say that?
Well, it's only 20 seconds.
Why does that matter?
A lot can happen outside of the remaining 20 seconds in our life.
Okay.
Prior to that, I would say, but yeah.
Sure. So I guess for you, what are your, what do you look for as far as an investigation to show that it was properly done?
I mean, simply put, if the officers are following the elements of the crime, the questions they're asking, the way they're describing the questions they're asking, how do they feel? Do I feel like they know what they're actually doing?
Okay.
Yeah.
Who else agrees that those are some important things, if anybody? Okay, 1 and 3, 2 shaking their head. Anybody else? Yeah, okay. So I understand you're number 5. You are a retired lawyer.
Yes,
Are you just retired altogether now, or are you working in another capacity?
my license is active, but I am essentially retired.
How long have you been retired?
About 4 years.
Okay. You're not tempted to jump back in?
Some of my coworkers have inquired periodically, but I haven't been inclined yet.
Trying to poach you. I understand. I understand. Okay, so let's talk about a couple of things. I know that Ms. Petrosky asked you guys about, let's just say somebody yanks your hair. Juror number 6, somebody yanks your hair, and how are you going to prove that they did that? Let's flip the script. Let's just say we walk out into the hallway. I'm going to choose you, juror number 4. Let's say we walk out into the hallway and we're having a polite conversation, and then we come back in, and I look at the judge and say, "Oh my gosh, judge, she just punched me in the stomach. I don't know what I'm gonna do." And you're like, "I'm sorry, what just happened? What are you talking about?" So if someone were to falsely accuse you of that, how would you defend yourself?
Would just give the facts as how it happened, because those are oftentimes the things that don't change.
Okay, okay. Thoughts? What do you guys think? Yes.
I would, just the way that he presented to the judge saying it, she just hit me in the stomach. I don't believe it. Why are you touching your head, touching your leg instead of holding your stomach where you got it?
Good point. Good point. Oh, my stomach, it hurts so bad.
Yeah,
Good point. Anybody else?
hopefully you got a camera up there in the hallway.
Camera, okay. So what if we were out there for 5 minutes and we show up with a 20-second video?
Somebody might have just started taking it and then taking the video and then, I don't know, just stop taking it.
Okay, so
I mean, you didn't like do the whole, like start at the beginning of whatever was occurring
mhm,
and keep going till the end of it.
okay, it's a fair point. Has anybody actually been falsely accused of something? I see you smiling.
Yeah, all the time when you're a police officer, I just laugh. about
Okay.
that, yeah.
So do people believe you when you say, "I didn't do it"?
I mean, yeah, it's more in that's why I laugh. It's more in jest and passing, you know, some.
Oh, okay, got it.
Not actual criminal or.
Right.
Yeah.
Well, has anybody been falsely accused of something? Somebody at work says, yes, juror number 3.
Yeah, I was accused of having a relationship with a fellow coworker.
Ooh, that's a tough one. Okay, so how did you defend yourself?
Just evidence, lack of evidence, because there was nothing that showed anything that was being accused of.
Okay,
The my coworker's testimony too, because there was nothing going on. So,
sure. So would you say that your story made more sense?
oh yeah, absolutely.
Okay. And it
Yeah,
kind of,
she didn't accuse. It was a student said they saw something happen between the two of us.
wow,
Which never
that's
happened. Yeah.
kind of convoluted,
It was-
unfortunate. But you're dealing with kids anywhere from what,
That was
up to
middle
high school? Middle school, okay, all right. All right, I get it. So I know we talked a little bit about, again, Ms. Petrosky gave a lot of really good examples. She was talking about, so you and your 2 kids, and how do you decide between them? Does anybody have 2 children? Okay, so we've got 3 folks with 2 children. When you're in a situation, and because see, when I was younger, we would go down to the basement and play in the basement, and inevitably the light bulb would get broken. And so of course everybody ran upstairs. He did it. I would point to my brother. She did it. He would point to me. And then mom's like, all right, who really did it? So the parents with 2 children, how do you decide who did it when they're both saying it was him, it was her?
Yes, everybody find out what stories make more sense.
Okay,
Put all the evidence together.
okay. Juror number 4.
My kids were always fairly honest with me.
God bless them.
But If there was a discrepancy, I would ask them to even walk through the story. No harsh punishment. If the stories were unfair to each other, but we find a way to reconcile, and so I'm not, things happen in life, and there are consequences. But if the intention is, if there's harm intended, then that's a different situation. Unfortunately, didn't have to experience that. So, so the child thing, as far as that goes, it's not. Unfortunate.
I'm so happy that you had that experience. I gotta say, my parents, I did not have that experience. We're all putting that out there. So, and yes, juror number 7.
Picture number 7. Yeah, I'm just not gonna punish either of them, most likely.
Okay,
Because if I can't get to the bottom of that, I mean, there's just gonna be no more crayons along the room.
no, that's a
Go right to the
punishment.
solution.
Okay, fair enough.
Yeah.
Yeah, I get it. Okay. Can you think of a reason why someone might lie in a situation where they are, let's start with making an accusation.
They don't want to get in trouble.
Okay, they don't want
Or
to get
they
in
want to go
trouble.
to jail. They don't.
Okay. So who are you thinking is lying in that scenario?
Probably the person being accused.
Okay,
I mean-
so Miss May is sitting here with me.
I mean,
And no, absolutely. I agree. Somebody might lie because they don't want to get in trouble. So, and we'll talk about this a little bit later, but she may or may not take a stand to testify. And if she gets up there, one of the things I'm concerned about is that you guys are going to think, oh, well, of course she's going to say that. She doesn't want to go to jail. She doesn't want to get in trouble. I get that. We'll come back to that later. But let's talk about someone who is making an accusation. Why might they lie? Yes.
Out of fear or out of vendetta.
Fear or those are like two very different things, right? So out of fear of what? What are they afraid of?
Perhaps they did something that they want to try to get the jump on someone else saying, oh,
Okay.
this is me, when actually something else happened previous to that.
Okay,
Vendetta, someone did something that they didn't like in the past, so now we blame you for doing this to get you in trouble.
hell hath no fury, right? No fury. What else, you guys? Yes.
Sometimes-
1 second.
Sometimes accusations are to make the person making the accusation look better. I've rooted out the trouble. I have come to make sure that this is coming clean to identify somebody that has
Mhm.
broken a law or broken a light bulb or whatever.
Sure. Juror number 6.
To get back at somebody, or they did, the person who's accusing it, if they did something first and then the other person did something, maybe they want to, like you said, you could jump on it. and say,
Sure.
oh no, this person did it first, so
Yeah.
my actions are just.
That makes sense. That makes sense. How many times would somebody have to lie before you didn't believe? Not rhetorical.
Once
Okay.
integrity is gone.
Okay, one time.
Depends on what they lie about and how far the extent of the lie goes. You say, oh, so-and-so, that you're with so-and-so, and then, oh yeah, I'm going out with so-and-so tonight, but that so-and-so doesn't exist, and they're continuing that lie, that lie, that lie.
Okay,
It just depends on how far they take it with their lie.
okay. That makes a lot of sense.
I think it depends on the consequences of the lie, because people can lie to avoid hurting feelings, and they can lie to get away with something. So it depends on the basis and the depth of the lie.
It's a fair point. Anybody else have thoughts on how many times somebody has to lie to you before you don't believe what they say?
to me, probably a couple.
A couple? Okay.
I mean.
You are more
'cause they-
forgiving than
I mean,
juror 7.
Yeah, because
Give them a little
sometimes,
pass.
and unless you can really prove that they lied, then there's a benefit of the doubt, I should say.
So do you agree that there are people that would lie and falsely accuse someone of domestic violence?
Yes.
Yes.
Looks pretty unanimous. Okay, okay. How many people here, how many of you would be open to the possibility after viewing the evidence that that is exactly what happened? Yeah, okay, yep, and I qualified it. I specifically said, depending on the evidence, just open to the fact that that may be what happened here. So a lot of times when there are relationships, there's a lot of emotions involved. Okay. You may see a situation where, and the parties are against Stephen Rutherford and Duana May. So there may be a situation where somebody gets emotional. And I don't do well with crying people. I really don't know what to do with them. People don't know what to do with me when I cry, and I certainly don't know what to do with people when they cry. So what should I do if somebody starts crying? Do I need to just stop questioning them?
Just
No.
give them a few minutes to
Okay.
let themselves or whatever, I guess.
Okay, that makes sense, because these are important questions, you guys. We need to get the answer. And it doesn't matter who's crying. She may get emotional. He may get emotional, but we need to get to the bottom of this. And I hope that you guys come along on that journey with me. So we talked, well, Ms. Petrosky talked a little bit about the burden of proof, and you heard some instructions on it. So if you took a vote right now, what would your vote be?
Not guilty.
Okay,
Don't talk about what,
a vote on guilt.
on guilt.
Yeah.
To these parties.
Yes.
Don't think the evidence or against it.
So what does that mean?
Okay,
Not guilty.
that means-
Right? Do you understand the point? I'm going around the bush to get to the point where we want. It's just kind of a way of saying, since there is no evidence, the presumption is she is innocent, and the burden of proof is on the government to get you guys to that point, if that's what happened. So the beyond a reasonable doubt, she talked a little bit about, it's not 100%. It is definitely not 100%, but it is the highest burden of proof that the legal system has. So I want to take you through kind of a continuum almost. And I put percentages on some of these because really that's the only way my mind can kind of come up with it. So this is my interpretation. How much proof does it take to pull you over for a traffic stop? Anybody know? Well, please go ahead.
To pull over for a
Yeah.
traffic stop, that's gonna be reasonable suspicion.
Okay. And so I put that's like the lowest burden we have. And I put that at like a 35% standard. And then since you are such a,
Probable cause.
okay,
Next.
probable cause is next. You are a perfect witness for this. So, and that is how much proof it costs, or it takes to,
Make an arrest.
okay. And so you would consider that to be a little bit higher.
Yeah, you're going from a detention to an arrest at that point.
Okay, so this is pulling them over to cuffing them and putting them in the car.
Right.
Okay. And then, so you may or may not know this one. I think you will be more likely to be able to hit this one. How much proof does it take to win a trial where somebody owes you money?
Usually preponderance of the evidence or just a little bit more than it is not likely.
Okay, and the way I describe that is I say it's 51%. It's a fancy way of saying probably, okay? And that's still not to beyond a reasonable doubt. And you're gonna be able to help me out on this one. How much does it take? How much proof does it take to take your kids away from somebody? Take their kids away from them? Does clear and convincing evidence sound familiar? Okay. And that is like, so you just heard me. This is to take your children out of your custody. Okay, clear and convincing. And we are still not to beyond a reasonable doubt. Okay. I don't have a percentage for that one. I don't really have a percentage for beyond a reasonable doubt either, but proof beyond a reasonable doubt is really, really high. So if you think about this, you can be clearly convinced that someone is guilty of something and still the right verdict is going to be not guilty. Does that make sense? Okay, okay. So you're also going to hear evidence about self-defense in this case, okay? And what you'll hear is the prosecutor has the burden not only to prove each of the elements of the crime beyond a reasonable doubt, but also has to disprove self-defense beyond a reasonable doubt. I saw you raise your eyebrows. Is that a surprise to you?
Yeah, that was mentioned.
Right. Well, and that's because she has her voir dire and I have mine. So she asks her questions and she's, you know, she doesn't know what evidence is going to come out.
Understood.
I'm assuming. Hoping. You know what I mean? So, what are you going to do if you think Duana is guilty, but the state hasn't convinced you both of the elements and that she did not act in self-defense beyond a reasonable doubt? If that's what the judge instructs you, then what do you do with that?
Don't you know that? And it's like the children.
Okay. And if she doesn't meet her burden of proof on both of those things, the verdict has to be what?
Not
Yeah.
guilty.
That's again pretty good. So we talked about, I don't know whether she's going to testify or not. Okay, we haven't made that decision yet. We haven't, the prosecution hasn't put on their witnesses yet. So we're still trying to figure that out. So everybody knows you cannot be forced to testify against yourself, right? So if you were accused of a crime, you would not have to sit in this chair. Judge told you she doesn't have to do anything. We don't have to do, I can file my nails over there through this whole trial. And if the state doesn't hit their burden, I don't have to put her on the stand. There's nothing that has to be done. What do you think about that rule? I know you
That's what she
guys.
hired you for.
What's that?
So that's what she hired you for.
What?
It's
How?
a defender.
That's true.
So
Let me ask you this. Who wants to hear the story? Yeah, don't be shy. I want to hear the story. Absolutely. So I saw like a few of you kind of like they were half raises, and am I assuming that everybody wants to hear what she has to say?
Yeah.
Okay. Okay. And that's fair. But if someone is falsely accused of a crime, what reason, what might they have to not want to testify? Fear their safety. Okay. Good one.
I mean, just personal opinion, what if we don't like them?
Sure, sure. What if she has some ticks?
Yeah.
Yeah, I got it.
Something that she says can be taken out of context.
Okay, something will be taken out of context. Yeah, that's a good answer too. Okay, so like I'm not that good of a public speaker now, but I was really horrible when I was younger. What about people that are like, man, I suck in front of people? I wear turtlenecks because I don't know if you can tell, but like my neck gets all red and splotchy. And I really am not interested in you guys seeing that. That's a secret that I'll let you in on. So this is what happens to me at every. Yeah, I mean, it's just, I have her freedom in my hands. And so I want to do a good job and I'm hard on myself. Anyway, that's beside the point. So do you think she might be concerned that she won't do well in a public speaking situation?
yes, yeah.
Okay. What about if I tell her, hey, I don't feel like the state has done what they need to do. So I don't think you need to testify. Could that be a reason?
Yeah.
Okay. So if I decide Duana doesn't need to testify, I don't tell you guys why. She just won't testify. Okay. And I understand that you guys want to know. How do you feel if she doesn't testify and you don't know the reasons? Okay. See a lot of head nodding. Any other opinions? Any other thoughts? Okay. So we talked about a little bit, I talked about self-defense. You guys know what self-defense is, right? Using reasonable force to act on your own behalf or the defense of others. If it's defense of others. What would you guys need to see in this case to make a determination that that's what happened? I see you starting to smile.
Well, I think about, some of the evidence, it's like when you were talking about whether or not you were punched in the stomach out in the hallway. Sometimes it's the proximity of when things come to light.
Mhm.
You know, did somebody say something immediately after this occurred?
Mhm.
Did they say something when they were defending themselves? Or was it a long time until you heard that?
Mhm.
Might make a difference.
Okay. Yeah. So kind of to piggyback off of that a little bit, you're going to hear that the complaining witness in this case did not report until later, the next day. Okay. And we talked about some reasons why somebody might wait to report. They were fearful, they were in shock, all valid reasons. Do you guys know, or do you know anybody who just people don't feel comfortable calling the police? Does anybody know somebody who's like, hey, wait, you're a cop and people that don't want to call the police?
Oh, yeah, it's constantly.
Really? Why? Why don't they want to call the police?
The color of their skin,
Okay.
family history, police.
Family history.
I mean, I could write you a 10-page paper, and I work with DEI, and I'm very familiar with when we do and don't call the police for certain situations because of someone's background.
Now I know I saw what you do. I don't know what DHDEI.
Diversity, equity, inclusion.
Okay, all right, yeah, all right. Okay, so what else are we thinking? Yes,
If you don't know what they're gonna be able to do about the situation.
Okay.
If you don't feel like they could handle it, or if it's kind of like outside of their limitations, and that's something that they can handle.
sure. All right, number 3.
Yeah, mistrust, not understanding if they're gonna handle it properly, but also a fear of any kind of reprisals from the person.
For making the phone call, right? Okay,
Not knowing they're right.
sure. Not knowing they're right.
But they'll say that they called them a few times and they didn't do anything about it.
Okay. Has anybody, do you guys know anybody that's grown up in a household that's like, we don't call the police? We don't know why, we just don't call the police. We never have.
Yeah,
Okay,
I know some families like that.
okay,
They try to handle things on their own.
okay. And sometimes is that handling on their own, and sometimes that's just
Yeah.
moving away, walking away from the situation?
Yeah, or they try to assault their,
Okay, take revenge.
Yeah,
That's another
like
option.
a revenge kind of thing, I guess.
Okay. All right. Hatfield McCoy's, is that?
Yeah, there you
Alright.
go.
All right, so that makes some sense. So we talked about self-defense, and we talked about, you talked about juror number 7, things that you were looking for. And I don't remember, did anybody, what else are you guys looking for to see self-defense? I think you talked about it a little bit, Mr. is it North Scott?
Yes.
Okay,
History.
history, what do you mean by that?
What's happened in the past that might have led to that altercation, or the mindset of the defendant.
Okay,
Time and stuff.
I'm thinking in that 20-second video, you said you got, if the other person struck them first and they pushed them away
mhm.
or assaulted them back, I guess to say.
Well, what if you don't hear any of that or see any of that? What if there's testimony, but all we have as far as visual stuff is a 20-second clip? I'm sorry.
Maybe what they're saying in the video,
Sure. Okay.
or how they're looking, or like if they got their hands in their face or
Sure. That makes
something
sense.
like that.
Okay. And I think,
Just to piggyback off of it, like if it's justifying, if somebody jumps out and scares you and you say, oh, I was in fear, I mean, you can't go off and attack somebody and say, oh, no, it's for self-defense. Like,
Yep.
it has to be justified through the means of what you're doing to that other individual justified for what they did to you, if that kind of makes sense.
Okay. And what you'll hear the judge talk about is you have to be in fear of your safety.
Right.
So certainly you guys will be able to make a determination as to whether evidence has come in regarding that, what happened. And I know you had your hand raised, please.
Oh, I just to piggyback off of his, proximity isn't really that important to me, you know, if it's something where there's a long history and maybe there's a week or two without, and then so that self-defense doesn't have to be immediate, but the fear of death or great bodily injury does.
Okay, so,
Or injury in this case.
gotcha,
yeah,
okay, great. I was thinking, oh.
Yeah, I
there's
think
no
like
death in
aggravated
this
assault,
case, I
yeah.
promise. Promise you that. So one of the things that you said earlier that I found was interesting is, you know, if, you know, someone is concerned that they won't like their mannerisms or like tics or something like that. So let's talk about that again. What if Duana does things that you don't like? What if you're like, oh, it's really annoying that she keeps tapping the table? What if her mannerisms don't rub you the wrong way?
I
Yes.
feel like that's not for us to judge.
Okay.
We're not judging her off of the mannerisms or how she speaks or, you know, what she's saying.
Okay,
The meaning behind what she's saying. We find evidence.
appreciate that. I love your smirk, like it starts and like works its way up, please.
I think depending upon when you see the tics or the reactions, if it comes to those particular questions that you have credibility issues on,
It's a fair point.
that might be a time to focus on the tick as like a poker tell,
Sure.
you know, where it's like, okay, the only time I see this tick is when I'm not sure that that sounds right,
Yeah,
you know.
absolutely. That's a really good point. All right, I've monopolized you guys long enough. I do have one final question. If you were sitting beside me in that chair, would you want you sitting on the jury?
Yes.
Okay. I appreciate your thoughtfulness, Ms. Baker.
Yes.
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 Okay, that was an affirmative from all jurors. I am done with this portion of review.
Mr. Chowski, challenges for cause.
Thank you, Your Honors. People would think excuse juror number 7 because indicated that he would not weigh the testimony of police officers equally to other witnesses and therefore indicated the ability to follow the law.
You said juror number 7,
Yes,
so he would not believe the testimony of other officers?
he said that he would hold them to a higher standard than he would hold the testimony of other officers and thus not weigh the testimony equally.
Any objection?
Judge, I believe that he indicated that he could weigh the evidence and determine whether there was guilt or innocence. I think he may have said that he would hold the officer to a higher standard, but it doesn't mean that he can't weigh the evidence and make a determination as to whether the evidence that comes in meets the burden of proof beyond a reasonable doubt. So I would object to that.
I did hear that statement, actually wrote down, when you asked him earlier in your voir dire about his ability to listen to the testimony of other officers and weigh that evidence. Can you expound on that? Are you saying that you would not be as equally fair and open to an officer versus a lay witness?
I would hold them to a higher standard because of their expertise in the situation.
You would hold the officer to a higher standard?
Correct.
I don't see how that would make him, and him being an officer, a former officer, how that makes him not fit to serve in this jury. So I'm going to overrule the objection.
Understood.
Okay. Any other challenges for cause?
No, Your Honor, thank you.
Challenge for cause.
No challenges for caution.
Preemptory. Mr. Shaw.
No, Your Honor, thank you.
And you're satisfied with the panel as it sits?
Yes.
Okay. Any preemptory?
Judge, we are satisfied with the jury. This is the simplest pick I've ever had.
Thank you. Well, Unfortunately, those of you all who waited so patiently won't get an opportunity to serve in today's jury. But I thank you for your willingness to participate in this process and to allow the parties to have their opportunity for a fair and impartial jury. I'm going to release you all first with the deputy administrator so that you can get further instruction. And then I got some instruction for those who are going to serve on today's jury. All rise so that the ones in the gallery can be dismissed. Okay, you can be seated. And it's been over an hour, so I have to give you a break, but also it's lunchtime. And we did call in lunch for the impaneled jurors. So you all are going to be released. We're going to take about a 38 minute, hopefully, break. I do have a 1:30 docket. So I need to clear that, and then we will go over further instructions and we will begin the proofs. Because I don't have time to go over the next set of instructions, I'm going to advise you of some rules that you need to be aware of. You are going to get a sticker that indicates and differentiates you as a juror while you're in the building. You're not to speak with anyone that's connected to this case. And since you don't know all the people that may potentially be connected with this case, you should be very cautious. If anyone that you believe is connected to this case does approach you or is having discussions around you, you should tell them to stop, let them know that you're a juror, and then you will report it to my staff once you return. We're not going to send you outside for lunch only because it's inclement weather. And we don't want to run the risk of anybody getting injured and then tying up the process. Plus, we only have a short time period whereby you're going to be able to have lunch. There's a juror room here that you'll be excused to. There's a restroom there. Obviously, if you need to go outside, get some air, smoke, pay your meters, or whatever you need to do during this next 30 minutes, you can do so. But I wanted to advise you of the rule about making sure you don't speak to anyone connected to this case. When you return promptly, you'll be officially sworn in as jurors on this matter, and we will go with further instructions and opening testimony. So all rise for the jury. You can be excused.